Hello everyone and welcome to today's Mondac webinar in association with Fabian Privacy Legal covering the new Swiss Data Protection Act. My name is Dan Sampaio and I'm joined by the wonderful Daniela Fabian to take us through today's discussion. Daniela is the founder and executive director of Fabian Privacy Legal, a boutique law firm specialized in international, European and Swiss data protection law, governance, risk management and program implementation. Daniela is a Swiss attorney at law and certified privacy professional with 30 years of professional experience, including as global head of data privacy at Novartis for many years. She advises multinational companies in the EU, Switzerland and the USA on data protection and security issues. Daniela is a member of various data protection associations and a frequent speaker and lecturer on data protection and digital marketing. Now, before I hand over to Daniela to begin today's webinar, a housekeeping item, you can submit a question to Daniela by typing it into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many as possible during our Q&A session after today's presentation, and we will make Daniela's contact information available for any additional inquiries. It's now my pleasure to hand you over to Daniela to begin. Thank you.
Thank you very much, Dan, for this introduction, and good morning to everyone also from my side. I'm very happy to walk you through the revised Swiss Data Protection Act and discuss the main changes. So we have a lot to cover, so I would say that we jump right into it. So next slide, please. So I will give you a short overview of the revised Act, the main concepts, the main differences to the current law in Switzerland, but also to the GDPR at a high level. We will then discuss the main obligations of the controllers and processors, look at the penal provisions, and then I give you also some implementation recommendation, and then we go to the questions. And as Dan said, if you have then additional questions after the webinar, you're welcome to reach out to me. So next slide, please. So on this slide, basically you see an overview of the developments in Switzerland. You see on the one hand, so in light gray color, these are the developments in the EU regarding data transfers. So the Schrems judgment and the recommendations of the European Data Protection Board and so on. On black, in black, you see the developments of the Swiss Data Protection Act, and this is the focus of today. And in blue, you see the developments in Switzerland regarding data transfers. So maybe if I can just walk you just briefly through this. So the revised Federal Data Protection Act, FADP, in Switzerland was adopted on 25th of September 2020, and it will come into force on September 1st next year, together with the two ordinances that belong to this act. Now, when it comes to the data transfer issues, probably you are aware, I mean, what was going on in the EU. The Switzerland basically followed the developments in the EU. So after the Schrems II judgment, also our Federal Data Protection and Information Commissioner concluded that the Swiss and US Privacy Shield does not approve an adequate level of protection. Then at the same day, like the EDPB, also the Swiss Commissioner published guidelines for international data transfers. The Commissioner also adopted then the EU standard contractor clauses. However, for Swiss transfers, we need to add some additional clauses, so we need to put an amendment on it. And like in the EU, the old standard contractor clauses can no longer be used, and we have to replace all these clauses by January 1st, 2023. So this is, in a nutshell, so the developments. Please, next slide. So the Federal Data Protection Act, FADP, was revised with the main objective to get into alignment with European law, with the Convention 108 on the one side, but also, of course, with the GDPR. It was adopted, as I said, in September 2020 and will enter into force on 1st September 23. There is no transitional period, so this means that all organizations need to be ready by 1st September 2023. The law regulates data processing by private persons, companies, and federal bodies, like the law today. In this webinar, we will focus on companies, on private persons, not on federal bodies. The law adopts many regulations of the GDPR, but it remains overall more pragmatic and more flexible. It remains principle-based, like the law today, so it's also less detailed than the GDPR. And very important, it retains the basic concept that we have already today, which is permission to process personal data subject to prohibition. So it's a contrary to the GDPR, which has a prohibition subject to permission. So in the GDPR, you always need to have a legal basis for data processing. In Switzerland, this is different. The law applies only to the processing of personal data of natural persons. This is new. And it applies to all actions that have an impact in Switzerland, even if they are carried abroad, which is the so-called impact principle. Next slide, please. So what applies according to the current FADP, just to see what then the differences are actually. So the scope changed. So it's personal data. It's all information relating to identified or identifiable natural or legal persons. This is today. In future, with the revised law, only natural persons will be subject to the law. The data protection principles already apply today, so principles of lawfulness, good faith, transparency, purpose limitation, proportionality, accuracy. However, there is no accountability principle, which is really regulated in the law, and this will remain the same also with the new law. The data subjects' rights, we know them already today, so the right to information, access rights, right to rectification, deletion, restriction of processing, and right to object. What comes new into the law is the right to data portability, like in the GDPR. Data security requirements are already in the law today, and also in the ordinance. There are some changes in there, but overall they remain the same. Today we have to register and maintain a register of data files and also register those under certain conditions to the Information Commissioner. This is today. With the new law, we will need to record processing activities like under the GDPR, and there is no registration obligations anymore. The due diligence for outsourcing, so due diligence of vendor assessments and also having a contract for outsourcing of data processing is already in the law, but there are some changes, but this we have already in the law. And also the rules for cross-border data transfers are already in the law. Next slide, please. So what is newly regulated? So first of all, as I mentioned, the material scope. So the law will only apply to natural persons, not anymore to legal persons. That is one which is really important. The territorial scope remains basically the same, but the principle is now explicitly regulated in the law. So the act applies to actions that have an effect in Switzerland. So also if they are carried out in another country. There is an extended duty to information. I will come to that more specifically just during the webinar. There is also an obligation to delete and anonymize personal data if they are no longer needed for the processing purposes. This is not really new, but it is now regulated in the law. As I mentioned, there is now a new right of data portability, like in the GDPR. The concept of privacy by design and privacy by default was also introduced in the law. We will talk about this during this webinar. There is an obligation to perform data privacy impact assessments. We will discuss this as well. There is no obligation, but organizations can nominate a data protection advisor with some benefits. We'll talk about this as well. Then the organizations need to, the controllers and process needs to maintain a record of processing activities, like in the GDPR. Now for outsourcing, we will discuss this as well. There is no change, but there is just one change, and the law now says specifically that sub-processing is not allowed without the prior authorization of the controller. We know that as well from the GDPR. For cross-border data transfers, one change is that in future, the Federal Council determines the adequate countries. Today, it is the Commissioner that maintains a list of countries that are considered being adequate, but in future, it will be a determination by the Federal Council, like the EU Commission does it for the EU. For data security, what was introduced was a risk-based approach. We know that as well from the GDPR. So that means that the more sensitive the data is, the more stringent the security measures must be. What has been introduced now newly in the law is an obligation to notify security breaches, so personal data breaches, to the Information Commissioner, and also to inform individuals under certain circumstances. I will come to that. There is an obligation also for companies that are abroad, so in other countries, to nominate a representative in Switzerland if they process personal data in Switzerland are under certain conditions that again are similar to those under the GDPR. The administrative measures have been extended for the Commissioner, and also the penal provisions have been tightened in the law. We will come to that. Just next slide, please. Okay, so where does the new Federal Data Protection Act differ mainly from the GDPR? The basic concept, as I mentioned, it's a concept of permission subject to prohibition. In the outcome, probably we come into the same conclusion, but it is really another approach which needs to be taken into consideration. The scope, it's an impact principle which goes a little bit beyond the territorial scope, and also the manual processing is subject to the law and not only automated processing or processing that will be part of a file, like in the GDPR. The accountability principle has not been included into the law, unlike the GDPR. The notification of data security breaches, yes, we have that now new in the law, but it is more pragmatic. I will then explain to you why this is the case. Then the duty of information is has been extended. I will come to that. There is a difference which goes a little bit beyond the GDPR, that in this information, it must be also stated in which countries the data might be transferred, irrespective of this country is a third country or if it is also an adequate country. So also if data is transferred from Switzerland to France, for example, then this needs to be stated. If it is a third country, then also the data subjects must be informed about the guarantees. And there are also a little bit more exceptions of this duty to information. And the penal provisions are different. We will come to that also during this webinar. Please, next slide. Okay, so what is personal data under the new act? So yeah, personal data is data that can identify a person. We have here on the left, I have listed what this can be. So this can be the identifiers, an email, name, a photo, identification number, passport number, personal social security number, a code, location data, online identification, and combination of factors. So this is really very similar to the GDPR and is also in line with the current data protection law. Then we have a set of sensitive personal data here. There is a change. So this is described in the law. You see it on the right. Data on religion, political views, and so on, health data. What is new now in the law is also genetic data and biometric data that uniquely identifies a natural person. This has been added to the definition of sensitive personal data. Then we have pseudonymous data. Now, this term is not defined in the Federal Data Protection Act, unlike in the GDPR, but the GDPR defines it. So we can go with the same definition. So it is personal data that can no longer be assigned to a person without additional information, and this additional information is stored separately and is secured. So in practice, what happens is that identifiers are replaced, for example, by a number. Now, Switzerland follows the relative approach. That means that only the party that has data and can actually identify the person, for that person, the data is personal. Is personal. For those persons that cannot identify the data subject, they have no technical, organizational, or legal means to do this. For that person, this data is quasi-anonymous. There is, of course, a huge debate about this relative and absolute approach, but this is the approach that also the Federal Council follows, and there has been also recent judgments about this topic. Anonymous data is like the GDPR. It's not personal data, so this is data that really cannot be allocated to any data subject. Next slide, please. Okay, now let's come to the data protection principles, which, as I said, are already in the law, but it's important just to recall what these are. So personal data must be processed lawfully and in good faith. The data must be proportionate, so data must be necessary, adequate, and appropriate for the purpose. So this is a data minimization principle, as we know. Purpose limitation principle, so the data may only be collected for a specific purpose that is evident to the data subject, and it must only be processed for that purpose or for a compatible purpose. So this means also when, of course, we draft privacy notices, we have to be to make sure that we really describe these purposes and be specific what we want to do with the data. The storage limitation principle is, or data retention principle. So as soon as personal data is no longer required to fulfill the purpose, that data should be destroyed, deleted, or anonymized. Next slide, please. The data accuracy principle. So the law now says specifically that anyone who processes personal data must ascertain that the data is accurate and must take also all relevant and appropriate measures to ensure that this data that is not accurate anymore is corrected, or if it's not complete, is completed, or otherwise deleted or destroyed if necessary. And this whole, let's say, correction must be also based, or the data protection measures must be risk-based. The data security principle, as I said, not much changed. However, a risk-based approach was introduced. The ordinance to the law describes or should describe the minimum requirements for data security. However, this ordinance does not contain really specific terms, but contains more the criteria to determine what measures needs to be implemented. I will come to that in a minute. In addition, personal data may not be processed against the express declaration of intent without justification. So if somebody says, I don't want that my data is processed, then you need to have a justification. This can be consent, an overriding private or public interest, or the law. And finally, sensitive personal data may not be disclosed to third parties without justification, the same justification as above. Today, we have the same principle in the law, but today we have also personality profiles. So for personality profiles, if these are shared with third parties, then we need to have a justification. Next slide, please. So this means that anyone who violates these data protection principles that I just mentioned must have a justification. So anyone who processes personal data in contradiction to these principles, or that shares sensitive personal information with third parties, or that want to process personal data against the will of the data subject, must have a justification. Now, the justifications, as I said, can be the consent of the data subject, the overriding private or public interest, or the law. Now, the Data Protection Act lists some examples of overriding private interests, which can be, for example, the processing the data of the contractual partner for the conclusion or execution of a contract. It does not make a difference whether the data is sensitive or not. The justifications are the same. However, within the justification, so there might be, again, some exemptions. So the private overriding interest cannot be applied in all cases. But this is described in detail in the law. Next slide, please. Okay, now I would like to address this topic, profile and high-risk profiling. This was a topic that was debated until the very end in Parliament, and it follows the GDPR to some extent. So let's see what it is. So profiling, and I put now the real definition that is in the law. So it's any type of automated processing of personal data that consists of using such data to evaluate certain personal aspects relating to the natural person. So to analyze or to predict aspects relating to that person, for example, job performance, the economic situation, the health, the personal interests, behaviors, and so on. So in short, it's automated processing that aims to evaluate personal aspects. The consequences are none. So there is no consequence. It's just a concept, profiling, but there are no direct consequences to that. High-risk profiling, this is something in addition. We don't know that in the GDPR, but high-risk profiling basically replaces the concept that we have today in the law, which is the personality profile. So high-risk profiling is profiling that involves a high risk to the personality or the rights of the data subjects by leading to the linking of different aspects and that allows the assessment of essential aspects of a person. So in short, again, automated processing, so profiling that leads to the linking of this data, so from different aspects. The consequences of this, because it is high risk, is a data protection impact assessment must be performed. There must be a protocol of this assessment, so the log of storage, modification, reading, etc. There must be a processing regulation or rules. And in addition, if consent is required as a legal justification, then that consent must be explicit. So there are some consequences for high-risk profiling. Next slide, please. Okay, so what are the duties of the controller and the processor? There is a duty to inform, There are duties that are based on the data subject's rights. So the access rights, the portability, correction and deletion. This means that, of course, the controller also must have processes in place in order to be able to grant these rights. Data processing by processors, so outsourcing, these are the duties that we know already in the law. Cross-border data transfer of personal data, here there are some duties. Privacy by design and privacy by default is new in the law. Data security requirements must be implemented. The data controller must notify in future data breaches. The controller must not notify to the authorities, but the process must notify to the controller, but not to the authorities. There is a duty to maintain the record of processing activities, and finally there is a duty to perform data protection impact assessments, and I will go now a little bit more into the specifics. Next slide, please. Okay, so duty to inform. So this means that the controller shall inform data subjects about direct or indirect collection of personal data. So far in the law, there is only a duty to information for sensitive data and personality profiles. In future, this information includes all types of personal data. So this is really a change, and this is something that organizations really need to look at, and eventually also to amend their data privacy notices. The Data Protection Ordinance contains the modalities of this duty. So the law lists some minimum content which needs to be provided in this information. It's like the GDPR Article 13 and 14. So we need to provide the controller's identity and contact information, the purpose of processing, if applicable, the recipients or categories of recipients, the categories of personal data, but only if the data is collected indirectly. In the case of cross-border data transfers, as I mentioned at the beginning, we have also to say in which states, in which countries the data will be transferred, and also if it's a third country, so a non-adequate country, then we need also to describe the transfer mechanism or the exception that we use. And in addition, this is new, if applicable, if there is an automated individual decision. So that means a decision that is based exclusively on the automated processing, which has a legal effect on the personal, on the data subject, then the information needs to include this aspect as well. There are some exceptions and restrictions. Basically, of course, if the person knows about this already, then the information needs not to be provided, but also if the processing is provided by law, or if the controller is bound by a legal obligation to secrecy, then there is no need to inform. And also if the information is collected indirectly, and the notification to the data subjects is just really difficult or would require a disproportionate effort, then also there is no need to, or there is an exception to inform. Then in addition, there are some limitations and waivers and so on, and the law lists here what these situations are. Now, the time of information, so when do we need to inform? So for direct information is at the time of collection. And for indirect collection, it's not later than 1 month after the receipt of the data, or if the data is shared with or disclosed with a third party, then this information must be provided at the time of disclosure. Next slide, please. Yeah, as I mentioned, the duty to inform in the case of an automated individual decision is new. So in Switzerland, really, under the new law, there is just a duty to inform. As I said, it's a decision that is based on automated processing. So both the assessment of the facts and the decision is made automated, so without a human being or a natural person. And this decision must have a legal consequence or affect the data subject. Now, so that means that if this is the case, the controller must inform the data subjects of this decision, and the data subject may request to state his or her position and ask also how the decision was reached. And the data subject may also require or request that a natural person, a human being, reviews this decision. Then there are some exceptions. Again, so no information must be provided if the data subject has consented to this decision being automated, or if this decision is related to a contract between the data subject and the controller. So next slide, please. So this is the duty of the record of processing activities. As I mentioned today, we have to maintain a register of filing systems, of data files. In future, we need to have a record of processing activities. It's like in the GDPR, it's the same thing. This is a duty that the controller and the processor must do, and there is no notification to the Information Commissioner anymore. The law contains some minimum information that must be collected or recorded. So the controller's identity, the purpose of processing, the descriptions of the categories of data subjects, the categories of recipients, retention periods, and also describe data security measures in a general way. And again, in the case of cross-border disclosure, the identification of the state and the safeguards. So this is the information that must be also included into the information or the data, the privacy notices to data subjects. Now, there is an exemption to maintain this record of processing activities, and this is where an organization has less than 250 employees and the data processing only leads to a low, or is only a low risk to the data subjects. Now, what is low risk? Here we can look into the ordinance. The ordinance says what high risk is, and so low risk would be if there is no extensive processing of sensitive data and there is no high risk profiling. So the ordinance says that extensive processing of personal data and high risk profiling are high risk. Ergo, low risk can be situations where actually this is not in place. Next slide, please. Maybe just I would like just to maybe say one thing in addition to what I just said before. Clear, this is the exception. Organizations really that fulfill this criteria may decide not to maintain a record of processing activities, but of course, maintaining a record of processing activities can have also benefits. It's important to know what data an organization has, how the data flows, if there are third parties. So it is really also a way in order to ensure compliance with all the data protection requirements. And so my recommendation is always anyway to have such documentation, but the law actually allows for exceptions. So data security, technical and organizational measures. So the law basically says very simple that the controller and the processor must ensure data security by applying technical and organizational measures. These measures should be able to prevent data security breaches. Now, the law also says that the Federal Council must describe the minimum requirements, and this is done in the Data Protection Ordinance. The ordinance, as I said, does not really contain specific minimum TOMs, but contains a criteria for determining the appropriateness and the protection goals. We'll come to that in a minute. So the controller and the processor are actually responsible to determine and implement the appropriate security measures based on the criteria. So they have to do this assessment, determine the measures, and then implement those measures. It's a risk-based approach, so depending on the types of information and on the risk, these measures may differ. Yeah, so in addition, the ordinance says that for automated processing of sensitive data on a large scale or high-risk profiling, the data controller and the process must in addition also keep a log and create processing regulations. Now, there will be some overlaps between this processing regulation and the log, and also the records of processing activities, but this is an additional requirement that is included in the ordinance. Next slide, please. So, as I mentioned, the controller and the processor must first determine the protection needs of the personal data, and then determine, based on these needs, the technical and organizational measures. As I said, the ordinance contains some criteria on how to do this. So the criteria for assessing the need for protection depends on the types of data. So is it sensitive data or not sensitive data, and so on. But also the purpose, nature, scope, and circumstances of the processing. So based on that, the control and process must assess the need of protection. So that's why it's also really important to know what data you have, otherwise this cannot be done. Based on that, control and process must determine the appropriate technical and organizational measures according to the risk. And again, the ordinance defines the criteria for determining the risk and the criteria for determining the TOMs. So for the risk, it depends on the causes of the risk, on the main hazards, on the measures that were already taken or are envisaged to mitigate the risk, and also the probability and severity of a data breach despite the measures that have been taken or are envisaged. The criteria for determining the TOMs depend on the state of the art, and we know that from the GDPR as well, and the implementation costs, and so on. So as I said, TOMs needs to be determined based on this assessment by the control and processor, but you will not find in the ordinance really specific TOMs. Next slide, please. The data security breach, as I mentioned, is a new obligation. So the notification of a data security breach is a new obligation in the law. The definition is similar to the definition in the GDPR. So it's a breach of security that results in personal data being lost, deleted, modified, stolen, and so on. Or also made accessible, of course, to unauthorized persons. So who must notify whom within what time frame? So it is the controller that must report the breach to the Federal Data Protection and Information Commissioner as soon as possible, and inform also the data subjects. Now, in the GDPR, we have a 72-hour we have 72 hours to notify this breach after becoming aware of it. Swiss law says as soon as possible, so we are more flexible here for this notification. The processor, on the other hand, must only notify the controller, again, as soon as possible. When to notify and inform? So again, it's a difference to the GDPR. So according to the Swiss law, the commissioner must be informed if the breach results or likely results in a high risk to the personality or the fundamental rights of data subjects. It's a case-by-case evaluation. The GDPR, for the GDPR, is risk is sufficient. So the bar is really higher for this notification. The information to data subjects, again, it's not when there is a high risk, but it is only if it is necessary for his or her protection. So only if the data subject is able to really do something, take some actions to minimize the risk or to mitigate the consequences, then the data subject must be informed. But it's not based just on high risk. Even if it's a high risk, but there is nothing that a data subject can do, then there is no obligation to inform them. But of course, I mean, it can be done, but there is no obligation. And the notification must describe the nature of the data breach, the consequences, and the measures taken or envisaged. This is very similar to the GDPR as well. Next slide, please. So the data protection impact assessment, again, this is a new requirement for the controllers. In practice, of course, controllers may do this as well today, but it's now really a new obligation in the law. So the controller shall conduct this DPIA if a planned data processing operation may entail a high risk to the personality or the rights of the data subject. What is a high risk? It arises particularly when new technologies are used, for example, the use of AI, but also if the types of data, the scope, the circumstances, and so on may lead to a high risk. So, for example, for automated individual decisions, for high-risk profiling, if sensitive personal data is extensively processed, or also if public areas are systematically monitored. In these cases, a DPIA is required, but not only in these cases. So there might be other situations where there might be a high risk for data subjects. So in these situations, a DPIA is required and also recommended, even if maybe according to the law you could argue it's not really required. If you are unsure, my recommendation is to do one, but only really if there is a risk of high risk for data subjects. What are the possible impacts of the processing for data subjects? And this can be taken into account when deciding or when determining if a DPIA is required. So data subject, so this could lead to the inability to exercise the rights or also access certain services. It could lead to the loss of control over the use of the data, loss of confidentiality, discrimination, identity theft or fraud, financial loss, reputational physical damage, or also the risk that pseudonymized data could be re-identified. So this could be the consequences for data subjects. And as I said, these can be taken into consideration when assessing the level of risk. Next slide, please. A data protection impact assessment is an assessment that should help the controller to assess the risk of a planned data processing operation and also to determine what measures need to be taken to mitigate those risks. So the DPIA contains a description of the planned data processing, an assessment of the risks for the data subject, and the measures taken or the measures that are envisaged to mitigate these risks. The DPIA must be performed before data processing, and in addition, if despite the measures that have been taken or will be taken, if there is still a high risk, then there is an obligation to consult with the Data Protection Information Commissioner. But there is one exception to this obligation. if the organization has appointed a data protection advisor, formally appointed, that meets also the requirements that are described in the law, and has consulted this data protection advisor, in this case, notification or consultation with the Federal Data Protection Information Commissioner is not required. So this is the reason why organizations that might be in a business where DPIAs are required, because the processing might be a high-risk processing in general, it's really to consider to appoint a data protection advisor, so to benefit also from this exception. As I mentioned before, the data protection advisor is not mandatory, but this is the benefit also of having one, besides, of course, other benefits of having a person that really looks after data protection and is responsible for it. Next slide, please. Outsourcing, as I mentioned at the beginning, this is not a new regulation. What is new is only that sub-processing is only allowed with specific or general authorization of the controller, but otherwise it is still, the rules are still the same. So basically, the controller may assign by contract or by legislation the processing of personal data to a processor if the data is processed in the same way as the controller is allowed to do, and if there are no legal or contractual confidentiality obligations that prohibits this assignment. When before outsourcing, of course, each controller should determine if the processor or if the service provider actually is a processor, and this is only the case if the service provider processes data on behalf of the controller. So there must be this determination at the beginning. If it's a processor, then the controller should conduct a due diligence, so should check whether the processor complies with data protection requirements and implements the appropriate security measures. So this is a vendor assessment that is performed either with a question, generally with a questionnaire, or also by other means. Then there is a need to have a contract between the controller and the processor, and this contract should specify the data protection and security measures, so it should include the instructions that the controller provides to the processor. Now, the Swiss law does not specify what needs to be included in such a contract, so it's unlike the GDPR. But as a best practice, generally, the Article 28, paragraph 3 is followed. Of course, we are more flexible. We are free to, to design this contract as we want. But as a best practice, we would follow the Article 28 requirements. If the processor is in a third country that is not adequate, then additional safeguards must be put in place. So this is typically the standard contractual clauses. And in addition, before transferring the data to such a processor in a third country that is not adequate, a transfer impact assessment must be performed as well. It's the same regulations like in the GDPR. Next slide, please. Exactly. So cross-border data transfers, as I mentioned, nothing has changed in principle in the law. So there is still the possibility, of course, to transfer the data to adequate countries without having any additional transfer mechanism in place. Or if it's not in an adequate country, then we have to put in place guarantees. Again, same thing like the GDPR. We have BCRs, and this is the main transfer mechanism, standard contractual clauses. The the Swiss Information Commissioner has adopted these standard contractor clauses. We don't have any specific Swiss clauses anymore. Maybe we will have a set again in the future, but now if we want to use standard contractor clauses, we use the EU standard contractor clauses with this amendment that I mentioned at the beginning. And in addition, also based on these rules and statements of the Federal Data Protection Information Commissioner, we also have to perform transfer impact assessments, same thing like in the EU, or for transfers from the EU to third countries. In addition, there are exceptions, of course, also. So a transfer would be, for example, allowed based on consent. Next slide, please. Quick word about the data protection advisor. I mentioned that already before. So the benefit of having one is you don't have to consult with the information commissioner in case of a DPIA, or in case of a really of a data processing activity that really has a high risk. The data protection advisor in this case would be the contact point for data protection authorities and data subjects, would train and advise the controller on data protection issues, and would also assist in the implementation of the law. And the requirements for such a data protection advisor to be a benefit for this DPIA is that the advisor should be independent, should not have any conflict of interest, should have the appropriate professional knowledge, yeah, so these are requirements. And the data protection advisor should then be, or must be, published and notified to the information commissioner. But as I said, it's not a must, it's voluntary to have one. Next slide, please. Yeah, privacy by design, privacy by default. This is very similar to the GDPR. Again, it's not a new obligation. It has been best practice today, but now it is really in the law. So it's all about really from the outset decide or determine how to implement the technical and organizational measures in order to comply with all the principles and obligations of the law. The terms must be appropriate, and privacy by default is also included in the law. This means that the controller must implement predefined settings to ensure the data minimization unless the data subject decides something different. Next slide, please. So we come now to the sanctions. The sanctions are described in the law. So on complaint, private persons, but in this case we mean individuals, are punished by a fine up to 250,000 Swiss francs if they violate certain specific obligations. This is the case if they do not, and it's always by intention. So if they intentionally provide false or incomplete information, if they are requested to provide information, or if they fail to inform data subjects, so this duty of information, if that is not complete, or if they fail to provide them with the information, with this minimum information that is described in the law. Also, if they process personal data in violation of Article 16 and 17, which are the articles that describe the cross-border data transfer. So if they transfer data cross-border without having standard contractor clauses in place, for example, if they intentionally assign data processing to a processor without meeting the conditions, so without having a contract and without performing a due diligence, so ensuring that they can really also, or that they have the appropriate security measures in place. Also, if they intentionally fail to comply with the minimum data security requirements, which are listed in the data protection ordinance, but what, as I said, it's not really, there are not really specific terms listed, but more the criteria, and who intentionally discloses secret personal data of which they have gained knowledge while exercising their profession, which requires knowledge of that data. And in addition, also they might be sanctioned if they do provide false information to the Information Commissioner in course of an investigation, or if they refuse to cooperate. So you see the list is much smaller. Under GDPR, basically any violation may lead to a sanction. Here it's smaller. Next slide. I'm not sure if this was the last. No, exactly. So there are some recommendations from my side on how to implement this whole Data Protection Act. So first of all, I recommend to conduct data management and compliance analysis to identify potential gaps, risks, and required actions. It's clear that those companies that have already implemented a data protection program, also based on the GDPR, may probably just need to do a few things, probably amend or maybe amend the data protection notice. Those companies that have not done yet or have not yet implemented a program may need to do a little bit more. I recommend really to implement the privacy by design process and also other processes to ensure deletion and destruction of personal data and to support data portability, to review the privacy statements and amend them if necessary, to create a record of processing activities, and also to implement processes to conduct compliance audits and data protection assessments if they are required. I also recommend to review the relationships with vendors and associated data flows, and then also to take the appropriate actions. Review your data security safeguards, conduct the assessments to see if the terms are appropriate and implement those if necessary. Have processes in place to handling data breach notifications and also requests from data subjects. And also one important thing is really to review the organizational structure for handling data protection and assess also if you need a data privacy advisor. Now, the organization structure is really also now considering the penalties to make sure that it's clear who actually is responsible for taking these decisions and for eventually risking a fine. And finally, review the internal standards and processes to ensure compliance with data protection requirements. And I think with that, I would like to maybe go to the questions.
Thank you very much, Daniela. And just before we go to the questions, I just want to say thank you very much for that incredibly informative session, Daniela. I can see that we've had plenty of questions that have come in from the audience, and we will take one or two of those. I don't think we'll have time for all of them, but please rest assured any questions that you have sent in that we haven't had time for will be forwarded on to Daniela. We'll also make Daniela's contact information available. You should be able to see that on your screen now. And we do encourage you to get in touch. But our first question, Daniela, does a sponsor of clinical trials need to set up a record of processing activities and a DPIA?
A sponsor of clinical trials, yes, they have to put in place a record of processing activities because the sponsor is considered a controller. And the DPIA, I would say, again, yes, this is the standard that they perform a DPIA. Now, again, a DPIA, of course, it's not necessary to do that for all single processing activities, but of course it can be put together. So similar processing activities can be subject to the same DPIA. It's the same concept like also under the GDPR. But yes.
Excellent, brilliant. Thank you, Daniela. I don't know if Daniela, you're able to see those questions that we've had in. If there's one that you want to pick that we can end on.
Yeah. So maybe, yeah, one of the questions that is often asked is also regarding the penalties, who actually will be responsible internally. And I think this is important. This is what I also mentioned before. It's important also to set up organizationally really who takes decisions. So as I said, the difference is it's an individual, and it's generally is a manager or somebody in a management position that is that has responsibility to make sure to comply with the law on the one hand, but also that is the one that has the authority to take decisions and to issue instructions. So it's not somebody who executes, not the executing associate, but it is somebody that really take these decisions. And this is really important to see. I'm often asked also in this connection, is it a DPO, for example, or an advisor? Could that be somebody? In principle, not, because it's not the person that takes decisions. But actually, if an advisor, for example, signs off on, I don't know, if there is an access request, signs off on the information that is to be provided, or signs off on a privacy notice, for example, then also an advisor might be subject to the penalty. But again, it's only intentional, so that the risk is not too high to get to get these fines. But as I said, these are the managers that would be fined.
Excellent. I think that's an incredibly important point and a good place to end today's session. As I say, we've had some fantastic questions in, and we will forward those on to Daniela, who will be in touch, but we do encourage you to reach out as well. So I would like to end today by thanking you for being with us. We really do appreciate it. And of course to Daniela for that fantastic presentation. Daniela, I'll hand over to you for any last comments before we close today's session. Thank you.
Yeah, thank you very much. No, I have nothing to add. It's a lot, of course, that we have covered. And I'm really happy if, I will look at the questions that you sent in. And again, if you have additional questions, do not hesitate also to contact me. I would be more than happy to respond. Thank you very much.
Thank you very much, Daniela. Thank you and goodbye.
Bye. Bye-bye.